Oluvannyuma lwe yali Ssengulu wa Uganda National Bureau of Standards, Dr. David Livingstone yebbira okuweebwa ekibaluwa ekimulagira okulabikako ku kkooti ku misango gy'obuli bw'enguzi. Ono yaggula omusango mu kkooti enkulu mu maaso g'omulamuzi Jane Kajuga ng'agamba nti eddembe lye lyatyoboolwa. Ebbiru yategeeza nti ofiisi ya kaliisoliiso wa gavumenti yatyoboola eddembe lye bwe yasalawo okumuggulako emisango nga tebannasooka kukola kunoonyereza. Era ano yasaba kkooti eyimirize ekiragiro ekimuyita mu kkooti. Ko n'emisango egimuvunaanibwa okumuggyibwako. Oludda olugabiro kyawakanya. Omulamuzi Jane Kajuga agobye okusaba kw'ebbiru bw'ategeezezza nti omusango guno yaguggula mu kkooti mu bukyamu.
Decisions to support his position, I see no need to reproduce them here, as counsel for the applicant conceded to the law on that. Having carefully considered the submissions of both parties, I resolved the issue by making recourse to the law governing the Anti-Corruption Court and the Human Rights Enforcement Act 2019. The Anti-Corruption Court was established by the High Court Anti-Corruption Division Practice Direction Legal Notice Number 9 of 2009, and by virtue of paragraphs 4 and 8.1 thereof, was imbued with the jurisdiction to adjudicate corruption and corruption-related cases. Specifically, this jurisdiction includes criminal offences under the Anti-Corruption Act, the Leadership Code Act, the Penal Code Act, and any other laws that may be related to corruption. These provisions are clear, they are unambiguous, and they establish that the court has only criminal and not civil jurisdiction, a position emphasized by paragraph 11 of Legal Notice 9 of 2009 jurisdiction. I've carefully considered the provisions of the same act. The long title of the act reads as follows: An act to give effect to Article 51 of the Constitution by providing for the procedure of enforcing human rights under Chapter 4 of the Constitution and related matters. Section 3 thereof provides that in accordance with Article 50, a person who claims that a fundamental or other right of freedom guaranteed under the Constitution has been infringed or threatened may apply for redress to a competent court. The interpretation section defines the competent court as the High Court or a Magistrate's Court. Section 3.2 sets out the locus standi, that is, who has the legal capacity to bring proceedings under Section 3.1, while Section 3 and 4 set out the jurisdiction of the High Court and the Magistrate Court in handling such matters. The provisions cited draw their power from Article 51 of the Constitution, which provides as follows: Any person who claims that a fundamental right or freedom guaranteed under this Constitution has been infringed or threatened is entitled to apply to a competent court for redress, which may include compensation. Article 52 continues as follows: that any person or organization may bring an action against the violation of another person or group's human rights. So the Human Rights Enforcement Act was enacted to give effect to Article 54 of the Constitution, 51 and 4, which provided that Parliament would make laws for the enforcement of the rights and freedoms in the Constitution. The Act sets out both civil and criminal mechanisms for the enforcement of human rights. Section 11, for example, makes it a criminal offense for a person to derogate from non-derogable rights and freedoms guaranteed under the Constitution, while subsection 3 provides that criminal proceedings may be instituted against a person who breaches a non-derogable right or freedom, even where an action, that is civil, for protection or enforcement of such a right or freedom has not been instituted. Other criminal offenses are created under Section 15, 6, and 9. Such offenses do not fall under the purview of the Anti-Corruption Act. They can be tried by ordinary courts with criminal jurisdiction. It also provides for the nullification of trials when non-derogable rights of an accused person are violated. Now, when considering the above cited provisions on the jurisdiction of the High Court, I'm referring to sections 3 and 4.
Kkooti eyongeddeko nti akagerike kiri nti omusango guvunaanibwa ebbiru teguleetebwanga mu kkooti nkulu. Tewali ngeri yonna kkooti eno gy'esobola kuwulirizaamu nsonga ze nga yeesigama ku nnyingo namba 78 mu mateeka agafuga kkooti ento. Omulamuzi ategeezezza nti kkooti ento erina obuyinza okuwuliriza ensonga z'ebbiru.
And the jurisdiction of the High Court in general to entertain matters of human rights. The context of the jurisdiction of the Anti-Corruption Court as a specialized division cannot be ignored. This jurisdiction is clearly delineated in Legal Notice 9 of 2009 and is limited. It follows, therefore, that not all human rights violation matters that may be filed in the High Court can be handled by the Anti-Corruption Division. I'm persuaded in this by the provisions of Section 7 and 8 of the Human Rights Enforcement Act, which I consider to be the relevant provisions as far as this case is concerned. And they provide as follows. Section 7. Where in any proceedings in a subordinate court, any question arises as to the violation of a fundamental right of freedom, the magistrate shall refer the question for determination by the High Court. 2. Where a human rights matter arises in any proceedings before the magistrate's court, the magistrate shall immediately stay the proceedings in the matter and first determine the human rights issue raised. 3. A magistrate presiding over proceedings referred to in subsection 1 may stay the proceedings until the reference is determined and may, in the case of a criminal trial, grant bail to the accused person. 4. The magistrate presiding over the matter shall dispose of the question referred to in subsection 1 in accordance with the determination of the High Court. 5. The court to which the reference is made shall, within 90 days from the date the reference is made, determine the reference made to it. Section 8 provides as follows, subsection 1. Where, in any proceedings in the High Court, a question arises as to the violation of a fundamental right of freedom, the presiding judge shall immediately stay the proceedings and determine the question raised. 2. The High Court may, upon staying the proceedings in subsection 1, in the case of a criminal trial, grant bail to the accused. It is clear from the above provisions that any court, whether civil or criminal, before whom a human rights violation is alleged in the course of the proceedings before it, is legally bound to address the alleged violation before proceeding with the substantive matter before it. For the magistrate's court, the judicial officer is expected to refer a matter to the High Court. Section 7.1 is couched in mandatory terms with the use of the word shall. Interestingly, the same provision does not draw a distinction between derogable and non-derogable rights, as it provides that where any question arises as to the violation of a fundamental right of freedom, the magistrate shall refer the question for determination by the High Court. This means that all alleged violations would have to be referred to the High Court for determination by the magistrate's court. It would appear from the foregoing that the Act, therefore, creates two categories of enforcement: actions that arise during proceedings and those that are instituted as standalone applications or matters within the meaning of Section 3 and 4 of the Act. The import of Section 7 and 8 of the Act is that where a magistrate or judge sitting at the Anti-Corruption Court is handling a corruption or corruption-related matter pursuant to its mandate under paragraphs 4 and 8 of Legal Notice 9 of 2009, it is vested with the jurisdiction to interrogate and resolve the question of violation of a fundamental right of freedom. This is the context within which the Anti-Corruption Court derives its jurisdiction. Counsel for the applicant submitted that when it comes to suits having a bearing on criminal proceedings, Parliament has restricted the forum for such suits to be the criminal courts handling the matter. I find this not to be the proper interpretation. The applicant must follow the procedure stipulated in Section 7 and 8 of the same Act. In this case, Section 7 requires that the matter be referred by the magistrate. I do not find the applicant's failure to follow the set procedure as a mere technicality that can be cured by Article 126(2)(e) of the Constitution. The application, therefore, is wrongly before me. I proceed, therefore, to dismiss it. I also proceed to dismiss miscellaneous application 54/2023 from which it arises for the same reason. The other miscellaneous application abated, the one for the interim, because we proceeded to hear the temporary injunction straight away. That's the ruling of the court. You will have it on ECMIS within maybe the next hour or so.
Oluvannyuma lw'okugoba okusaba kwe kati Dr. David Livingstone Yebiru waakuvunaanibwa emisango egyamugulwaako mu kkooti ento. Emisango gino kigambibwa nti David Livingstone Yebiru yawa enguzi ya bukadde 10 eri Charles Maseruka, ssentebe w'akakiiko akafuzi aka UNBS, n'ekigendererwa eky'okusigaza omulimu gwe nga ssentebe wa UNBS. Mu ngendo ate woofiisi ya Ssaababe wa gavumenti eggyeyo emisango gyonna egyali jaggulwa ku General Muhoozi ne Rugaba mu kkooti ya Buganda Road mu Kampala ekubirizibwa omulamuzi Ronald Kayizi. Oludda oluwabi nga lukulembeddwamu Ivan Chazze lutegeezezza kkooti nga batali beetegefu kugenda maaso na musango guno.
Yes, at Buganda Road Court this afternoon DPP has presented a withdrawal form that she's withdrawing a case against Muhoozi ne Rugaba. Of course, as expected, because the reason why I've been challenging their takeover is because they normally take over the cases and kill them. Contrary to the Constitution, because the Constitution Article 120 tells them you take over and continue. Now, even the form they brought, the Constitution says they need the consent of court. Now, it has been a hurdle with Chief Magistrate Kayizi, of course with his incompetence, as I'm going to report him to the Service Commission, that when the Constitution says with consent, you need to hear from the person who brought the case. Because this is not a case opened by DPP, but
take over a privately prosecuted case and thereafter drop it. First and foremost, it must be noted that she is in charge or in control of prosecutions. So she's mandated by the Constitution to control prosecutions, and that also implies that she can take over private prosecutions and either continue the prosecutions or discontinue them if there's reason to discontinue them. The DPP may discontinue private prosecutions for a number of reasons, which include where there's no evidence to support a case, then there would be no reason for her to proceed with that kind of case. She would then have to withdraw it from court. She can also withdraw a case where there's evidence that there's abuse of court process. So we have encountered a number of cases where private prosecutors institute cases for a number of reasons, but you can see that they're not legitimate. Maybe they're trying to get at people. So if the DPP assesses the case and realizes that it has been instituted maliciously or with intent to abuse the judicial process or the criminal justice process, then she'll be moved to withdraw such a case.
Asani mane Mabirizi yaggula omusango guno ku General Muhoozi ne Rugaba alaze obutali bumativu eri woofiisi ya Ssaababe wa gavumenti okulemerwanga okugenda maaso n'emisango gye, era ategeezezza nti waakujulira.
N'agamba ayagala kujja omusango gwa Muhoozi ne Rugaba. Leero mbaddewo nnyo okuva ku makya. Kayizi n'ayimiriza kkooti n'agamba agenze kusinkana Owonyiddulo n'embeerawo nga nja kulaba kye bakola. Bwe bazze nze omujulizi mbaddewo, complainant mbaddewo. Chazze n'agamba alina foomu wa DPP ageyo omusango era n'agamba abadde ayita mu Kawalo 12 akassemateeka 3. Mu kawaayiro ako DPP bamugaana okujjayo omusango gw'ataleeta mpozi ng'alina consent ya kkooti. Neera nga mukimanyi n'obuyinza obw'okutwala omusango babumuwa nti agutwale agenda nagwo mu maaso. Akati ye newankwadde omujulizi nabaddewo n'abalanga nja bayita oluzze agamba ayagala kugujjayo. Ne ngamba Kayizi omusango guno gujjayo olina okumpulira kyekibagamba nti ogaba consent. Kayizi agaanye okumpulira. Mu kugaana okumpulira n'agamba sina lokasi n'agamba DPP byagambye nti wali bujulizi naye ng'omujulizi wendi nti bituufu omusango akkiriza okugujjayo. Ne Kayizi ne mulaba ne mugaa Kayizi byokola bijja kukosinga walawo n'abazzukulu. Kuba ssemateeka ali clear mu kakitundu 12 3D olina okugaba consent. Consent olina okuwulira omuntu eyaleeta omusango mu kooti lwaki bagujjayo, especially nga waali kuba mbaddewo mu kooti nakumye okuva ku makya n'agenda n'okumupa ku olweggulo n'agamba mbu agujjayo n'aseka ne mugamba muzannyire mu nsi n'emujja kiraba. Kayizi era namusuubiza omutwala mu Justice Commission kati njja mutwalayo kubanga omusawo guno aguzannyiddemu nnyo fayiro ajja kugalole mu ngeri y'amankwetu. Namugamba ayimirize ebintu bino paka koto bapiriwe n'asala n'angamba musina lokasi mu application yange gyendeese sensokoza ndona bajazi munoonyerezaako naye era kitugenda okukola ekirala kyakugenda kwa court tuwakanye enkola n'ekimpatire ekyayita mabika kubeera ssemateeka. Neera kinabadde mbagamba abantu bali bagala lwaki owakanya DPP twala emisango gyo. Ne mbagamba talina abodonga buno mumanyi mu incompetence n'enkola y'ebintu y'ekiyayiyayi akolera ku orders talina maanyi gonna gagonyeza ku Muhoozi oba n'ababembera mpaabidde buli gwempaaba gwajjayo nabagamba yajjayo Gwakyagulanye yajjayo Gowunyiddolo yajjayo Gwalajivu ye kyakola kusayininga byakiyayi ku Lajivu omutwalo wa Sudi waliwo n'obujulizi obwenkunala nti yali ayotaka mu nnyanja ku Kyagulanyi enkola zaaliwo ne kaakati ku luno nze kennyini wendi kati ekisooka kya abodde kyojadde nakyo mu High Court nene ekya Kayizi okubeera nti ali incompetent nti Ssemateeka amugamba nti atuwulire n'atatuwulira n'akola byakoze eki byayagala so kyetubali tubagamba bulijjo nti lwaki tubakiriza twala emisango gyaffe kubanga bo kye bafuba okulaba at the end of the day nti batta buli musango gwe tuleeta omujulizi ne waba waali abajulizi ne baba tebaliwo so nga bo bayita emisango y'ekibatira ne gimala n'emyaka 2 mu makooti kati balina mujulizi n'omu eyo jjo bagiwoyisa ne bagirindalinda naye gyaffe bajjawo mijje so ensonga ezo zigeragera mu High Court zijja genda mu East African Court of Justice olwedde eri apiiru yaffe mu Court of Appeal ewakanya ensala y'erubu okugamba nti omusango DPP agutwala eyo tesobola kuba affected kuba kasite yange egamba nti bali bakola nsobi olubi yakola nsobi okugamba nti DPP akola omusango mu butuufu olubi yakola nsobi okujjako kya kiiti yange ey'okubiri kuba emisango bajje ku Muhoozi tebajje kubali baani babbala munene gye bagiri ku Muhoozi kasi Court of Appeal eragira nti omusango giddemu jjudde buto ayitayiza agamba nti DPP yagijjawo kubanga DPP gya kumugobamu nze kennyini nzije neewoleza emisango gyange ate kati ngenda nkunya kukola Court of Appeal nti bano okumanya bayaayi n'emisango gyennyini wayita mpaawo kaaga bajemera constitution ne bagijjayo ate Constitutional Court era yakamala okutaputa newabula negamba nti DPP mu kesi ya Kayihura nti talina buyinza bujja kutwala musango n'agujjayo nti DPP Ssemateeka obuyinza bw'omuwa buli bumu bakutwala musango alabenga agwongerayo kibamugamba kyalina okukola kakati waba takikoze then ensonga ezo kyemmanyi Court of Appeal gyasunamu bulungi era tebeeyibaala gyakola kwayo kooti n'okuba Appeal gye tuli era kati fayiro tugenda okulaba nga fayiro eyitibwa eyambuke bwena amala okwambuka babenga ensonga zonna zitambula bukwako naye nga tugenda kukivaako ogw'okumi gye guli gukomawo wiiki ejja nga 27 tujja kubaabira n'emirala oba baagala kutwala bagende bagitwala paka naye tugenda kulekera naye kimanyi tugenda tutuuka ekiseera okuba tekukyabayamba nga kooti emaze okularifayinga nti era singa Ssemateeka bw'agamba nti okutwala ogenda nagwo mu maaso togutwala nakugula.
Mu kkooti ya Buganda Road General Muhoozi Kayine Rugaba abadde avunaanibwa omusango okumenya amateeka wamu n'okweyisa mu ngeri etasaana ku bigambibwa nti yeetaba mu byobufuzi ate ng'akyali musirikale wa UPDF.